I'm live. I'm live. They say I'm live. I hope I'm live. Anyways, all right. We're already a paragraph in, folks. Oh, hey, folks! Welcome to law school shit. We're doing our homework for modern American remedies, cases, and materials by Laycock, Cock, and Hansen. We're at page 55. We're going through the response and proposal from KT Master about this fucking machine. Apparently, was furnished from Milwaukee, the Milwaukee Matic 180. Already sounds like a scam. Okay, so here is the written proposal for the contract. Warranty, disclaimer, limitation of liability and remedy. Seller warrants the products furnished hereunto to be free from defects in material and workmanship for the shorter of little I 12 months from the date of delivery, or little two I's, little Roman numeral 2, 4,000 operating hours. So this is the rest of the, for whatever reason, the rest of this contract is in bold. So we're just gonna go with it. Under no circumstances will seller be liable for any incident or consequential damages, or for any other loss, damage, or expense of any kind, including loss or profits arising in connection with the contractor with or the use of or inability to use the seller's products furnished under the courts. Under this contract, the seller's maximum liability shall not exceed the buyer's remedy, and it's limited to either 1, the repair and placement of the effective or defective part, or 2, the product at the seller's option, or 2, return of the product and refund of the purchase price, and such remedy shall be the buyer's entire and exclusive remedy. According to the master's witnesses, the machine malfunctioned frequently during the first year of operation. It was inoperable from 25% to 50% of the time. Well, that sucks. Over KT's objection, testimony was introduced estimating the lost profits on customer orders allegedly unfilled because of the inoperability of the machine. The trial court instructed the jury that it could award consequential damages, notwithstanding the contractual exclusion, if it found that KT had failed to make the machine as warranted. End quote. The jury returned a verdict in favor of Master, not that Master, you bigots, of Master Engraving. Thank you for playing. For $57,000. In affirming the appellate division, that's what it says. Yeah. In affirming the appellate division, interpret the jury verdict to mean that the limited remedy of repair and placement has failed of its essential purpose. Section 2-7192 51A 2D 1227 New Jersey Superior Court Appellate Division 1987. Section 2 of the case. Under the code, consequential losses constitute a recoverable item of damages in the event of a breach by the seller. Section 2 TAC 7143. However, the potential significance of liability for consequential damages in commercial transactions undoubtedly prompted the code's drafters, consistent with the code's endorsement of the principle of freedom of contract, to make express provision for the limitation or exclusion of such damages in Section 2 TAC 719 footnote 3. Going to footnote 3. I need a footnote voice. We need to do that. Footnote voice. Wait. The trial court also instructed the jury to consider the representation in the sales brochure about the MM1A's amazing low maintenance requirements as constituting an express warranty of the machine's performance. K&T does not challenge this ruling, and thus Section 2-7193 provides, quote, consequential damages may be limited or excluded unless the limitation or exclusion is unconscionable. Limitation of consequential damages for injury of the person in the case of the consumer goods is prima facie unconscionable, but limitation of damages where the loss is commercial is not. Jesus. Section 2. Under the code, consequential losses constitute a recoverable item of damages in the event of a breach by the seller. Section 2, TAC 714, subsection 3. However, the potential significance of the liability for consequential damages in commercial transactions undoubtedly prompted the code's drafters, consistent with the code's endorsement of the principle of freedom of contract, to make express provisions for limitation or exclusion of such damages. Section 2-1719. As one commenter has observed, no, that's my footnote voice. Sorry. As a general matter, consequential damages exclusions are hands down the most significant limitation of liability in a contract for the sale of goods, all of the goods. Potential liability for consequential damages in commercial context, usually in the form of the buyer's lost profits from the use or the resale of goods, is in his business. It's enormous. It's enormous in comparison to the contract price of those goods. You know, we like those goods. On the other hand, the general or direct damages that a buyer may suffer upon a seller's breach are finite and and can be granted at a maximum amount, either in terms of the contract price or the market price of them goodies to be sold. Roy Ryden Anderson. Well, that's an unfortunate name. From the treatise Failure of Essential Purpose for Essential Failure on. Whoa, what? The name of the treatise is Failure of Essential Purpose and Essential Failure on Purpose. I'll look at, that's clever. I'll look at section 2-719 of the Universal Code. Clever name, bro. I'm with that. I'm here for that. In a commercial setting, the seller's right to exclusion of consequential damages is recognized as a beneficial risk allocation device that reduces the seller's exposure in the event of a breach. An equally fundamental principle of the code, comparable, depends if you're from Britain or America, in importance to the right of parties to limit or exclude consequential damages, is the code's insistence that I don't have another voice. I need another voice. I'll just do a serious voice. It is the very essence of a sales contract that at least minimum adequate remedies are available. If the parties intend to conclude a contract for sale within this article, they must accept the legal consequence that they be at least a fair quantum of remedy for the breach and of the obligations or duties outlined in the contract. Thus, any clause purporting or to modify or to limit the remedial provisions of this article is an unconscionable manner, is subject to its deletion, and in the event that remedies are made available by this article are applicable as if the stricken clause had never existed at all. Similarly, under subsection 2, the dose, where an apparently fair and reasonable clause because of the circumstances fails in its purpose or operates to deprive either party of the substantial value of the bargain, it must give way to the general remedy of the provisions of this article. Comment 1, section 2-179 says, these competing policies, freedom of contract, including the right to exclude liability for consequential damages. Hang on, nicotine break. Dude, another nicotine break. Rock and roll. Oof. You there? All right.
Yeah.
Wait, where was I? The nicotine has screwed my mind. It's so much better now. Okay. These policies, freedom to contract, including the right to exclude liability from consequential damages, and the insistence upon minimum adequate remedies to redress the breach of contract, frame the issue before us. If a limitation or exclusion of consequential damages is not unconscionable when the contract is made, must it be upheld unenforced? They use double negatives all over the place. must it be upheld if the limited remedies provided in the contract do not achieve their intended purpose. So basically, unconscionability, for those watching out there in TV land, there's one of you. I see one of you. Hey, viewer.
Hi.
Hi. Well, I get technically 3 viewers, I guess. But whatever. Anyways. So, unconscionability is a separate legal statute that says, "Oh, hi, I see you. I see you in the chat, Pookie. Hey, like and subscribe. Hey, Sato. Shut up, Mokuba." Anyways, so unconscionable, since we're just doing a colloquy now, we're just talking, right? Unconscionability is the circumstances under which our contract is formed, right? And so basically, lols to you too, Dr. Pookie. So unconscionability is a standard by which, so for example, if somebody was going to get married, let's say, right? And I was like, hey, sign this prenup, bitch. And you're like, I don't want it. And like, excuse me, sign this prenup or else it's not going to happen. And then I had like millions of dollars hidden in my secret bank accounts in Iran, right? And like, I didn't tell you about those in the prenup, and you signed the prenup anyway because like, sign this or else, right? Then that's unconscionable because I pressured you into the signing of the agreement. So fraud, like plain fraud, duress, undue duress, or lack of knowledge are bases for unconscionability in American law. So that's what that means. To the extent the UCC addresses this issue, that's the Uniform Commercial Code, its response is inconclusive. The code provides merely that when a limited remedy fails of its essential purpose, remedy may be held as provided in this Act 2 TAC 719-2. Consequential damages address a buyer's remedy as provided in this Act 2 TAC 714-3. But the code is silent, meaning there's nothing in it. It's not actually silent, it just doesn't have anything in it. As to whether that remedy survives the sales contract, survives if the sales contract excludes it. A related question concerns the extent of remedies other than consequential damages that are available to a buyer relegated to a limited remedy that has failed to achieve its essential purpose. Typically, the limited remedy most often offered by sellers is the repair and replacement warranty. Oh, yeah. I forgot. We were talking about a freaking stamping machine that this fucking company bought. Like fucking 4 pages ago, we were talking about that. Now, okay, we're okay. The whole problem is they made a stamping machine that half the time didn't work. That's what we're talking about. Typically, the limited remedy most often offered by sellers is the repair and replacement warranty found in the sales contract. In this case, when a repair and replacement warranty is combined, as here, with an exclusion of consequential damages, the commercial objectives of the contracting parties are reasonably evident. Oh my God. As summarized in Beal versus General Motors Corporation, don't buy a GM. 354 FedSup 243 426 1973. The purpose of an exclusive remedy of replacement or repair of defective parts is to give the seller an opportunity to make goods conforming while limiting the risks to which the seller is subject by excluding direct and or consequential damages that may otherwise arise. From the point of view of the buyer, the purpose... I'm Australian now, apparently. Okay. From a point of view of the buyer, the purpose of the exclusive remedy is to give him goods that will conform to the contract with a reasonable time after a defective part is discovered. When the warrantor fails to correct the defect as promised within a reasonable time, he is liable for a breach of the warranty. Crikey. The commonly applied formula to compute a buyer's damages for a breach of any warranty, including the repair or replacement warranty, is the difference between... Back to Britain. Is a difference between... That's still Australian. Whatever. Is the difference between the good value of the goods accepted and the value... I ran out of accents. And the value they would have had if they had been warranted. 2 TAC 7142. The code also affords the buyer the right to recover incidental damages to TAC 7143, as well as the right to revoke acceptance of the goods. Okay, that means, okay, they send you the shit, and you're like, this is not the shit I ordered. Take it back. That's revocation. That's what revoke means, right? Within a reasonable time. So you can't like get the stuff. You're like, oh, this is the thing, and put it in your basement for 3 years, and then like be like Samuel L. Jackson with that white girl tied to his radiator, and you're just like, oh, hey, next to that white girl, there was a bunch of stuff I ordered from the widget factory, and I don't want these widgets anymore. 3 years later, no, it's got to be reasonable, right? Now, no comment on the white girl changing the radiator. That's a topic for another day. But so you can revoke the sales of the goods, right? And then, like, I don't want this stuff taken away from me, and they have to like take it back. All right. Courts have considered the validity of the exclusion of consequential damages in the context of a repair or replacement warranty that has not fulfilled its purpose have reached significantly different results. Basically, the courts don't know what the hell is going on here, so now we have to freaking what? Oh, I can put you in timeout for 10 minutes. That's hilarious. YouTube just told me I can put you in timeout for 10 minutes. I'm not going to, but that'd be funny. I'm going to put my one viewer in timeout. Anyway, but YouTube just like interrupted the stream to tell me I can put you in timeout. I would never do that. But YouTube says I can. I'll put Seto in timeout. Shut up, Mokuba. Courts have considered the validity of the exclusion of consequential damage in context of blah, 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 blah. A substantial number of courts seem to have adopted the view that there is an integral relationship between the exclusion of consequential damages and the limited remedy of repair or replacement, so that the failure of the limited remedy necessarily causes the invalidation of the exclusion of consequential damages. Characteristic of the rationale employed by these courts is this excerpt. Viewers, all you viewers, give me an accent to do. I need an accent. In the chat. Hey, you millions of people, send me an accent you want me to do in the chat. We'll see if we can do it. Because I have another quote to read that's boring as fuck. Thank you, Dr. Pookie. All right, man. Here we go now. If this is a specific breach of the warranty to repair, the plaintiff alleges the cause of the bulk of the damages, the court would be in an untenable position, man, if it allowed the defendant to shelter itself behind one segment, man, of the warranty, when it has allegedly repudiated and ignored the very limited obligation under another segment of the same warranty, which alleged repudiation, I'm out of it now, which alleged repudiation, oh wow, which alleged repudiation, man, has caused the very need for the relief which the defendant is attempting to avoid. Irie, man. Jones versus McKnight Corp versus versus Birdsboro Corp, 320 Feds up 39, 33 through 44. New ND 3rd, 1970. What the fuck state's name is ND? Whatever the freaking state this name is, initials are ND, not New Delaware. That's not a state. ND. North Dakota. Where I was born. North Dakota. 1970. In a sharp contrast, a number of other courts have concluded that an exclusion of consequential damages is to be viewed independently of a limited warranty of repair or replacement, so that if the warranty fails to fulfill its purpose, the validity of the consequential damages exclusion depends upon the specific circumstances and the probable intention of the parties. The Third Circuit's opinion in Chatlos 1, it's a case, is typical of the reasoning articulated in these cases. Chatlos Systems Incorporated versus National Cash Register Incorporated. 635 Fed 2D 1080 Third Circuit 1980. In Chatlos 2, which is they came up again. They didn't fucking settle it. They came up again. Oh, Good job, Pookie. You knew what the code before I did. Thanks, Pookie. Like and subscribe. So Chatlos 2 is reprinted in section 2C of the fucking second federal supplement of 635 at page 1080. Quote, the sales agreement warranted that the system would be free from defects for 12 months, excluded liability for consequential damages, and limited NCRs, which is the respondent's responsibilities, to the correction of any errors or defects within 60 days. Need another accent. It's coming up. So, chat, hit me an accent. The Third Circuit agreed limited repair remedy has failed of its essential purpose, but reversal of the trial court's award of consequential damages, including that the contractual exclusion of consequential damage, should be enforced. All right. We knew that. But I was going to Australian. All right. British. The baby always say, I'm British. I'm British. I'm like, no, you're just talking like a crazy person. All right. Okay. We can do this. It appears to us a better reasoned approach to treat the consequential damage disclaimer as an independent provision, as an independent provision, valid and less unconscionable. The limited remedy of repair and consequential damages exclusion are two discrete ways of attempting to limit recovery for a breach of a warranty. The code, moreover, tests each by a different standard. The former survives unless it fails the essential purpose, while the latter is valid unless it's unconscionable. We therefore see no reason to hold as a general proposition that the failure of a limited warranty provided in the contract without more invalidates a wholly distinct term in the agreement, excluding consequential damages. Whether the preclusion of consequential damages should be effective in this case depends upon the circumstances involved, obviously. The repair remedy failure of essential purpose, where a discrete opposition question, is not completely irrelevant to the issue of the consequence about conscionability of an enforcement of the consequential damages exclusion, i.e., a question here narrows the unconscionability of the buyer retaining the risk of consequential damages upon the failure of the essential purpose of the exclusive repair remedy. That's good. I can't do that. I don't do gay. Sorry. Well, I did actually. I already did gay, so I guess I do. I don't do hairy gay, or gay hairy, or furry, whatever. My God, we're almost there. We only have a page and a half to go. Jesus, freaking criminally. 635 Federal District 2 at page 1086 to 1087. We are also persuaded that many do you even know what the hell you just said? How are you persuaded? I'm not persuaded. I don't even know what the hell is going on. We're talking about an engraving machine that you sold that fucked up and didn't work. We are also persuaded, apparently they're persuaded, that many routine business transactions will be dislocated by a rule requiring the invalidation of a consequential damage exclusion wherever the prescribed contractual remedy fails to operate as intended. The commercial reality is that for many sellers, immunity from liability of their customers' consequential damages may be indispensable for their pricing structure and in extreme cases to their solvency. Meaning, like, if they're like, I guess if your whole market is like, we're going to sell you broken ass machines that don't work, and then you're going to sue us because they don't work, then that's going to bankrupt us, which just maybe they should. That kind of makes sense. Like, okay, fair enough. Nor do we find that enforcement of consequential damages limitation when a limited remedy has failed of its essential purpose is necessarily inequitable. So necessarily inequitable means it's necessarily equitable. Thanks, court. To the buyer. As noted earlier, the code affords remedies other than consequential damages when a warranty is breached. Accordingly, we conclude that 2-7. Oh, gotcha. I see it. I see your chat. Thanks. Yep. Thanks for your chat. We're it. Accordingly, we conclude that 2-TAC 719 does not require the invalidation of an exclusion of consequential damages when limited contractual remedies fail of their essential purpose. Is only, but there's no quotes. I can't do the quotes unless we actually have quotes. It's only, just wait. It's only when the circumstance of the transaction, including the seller's breach, causes the consequential damage exclusion to be inconsistent with intent. You're causing from Boston. It means okay to Beer Fest. There you go. For my fangirls out there. Only when the circumstance of the transaction, including seller's breach, causes the consequential damage exclusion being consistent with the intent and the reasonable commercial expectation of the parties that invalidation of the exclusionary clause, this will be on the test, so pay attention, will be appropriate under the code. For example, here's an example. Do we know what they're talking about? Fuck no, but here's an example. For example, although a buyer may agree that the exclusion of the consequential damages of Park the Car and Haven Yard, a seller's wrongful repudiation. I just sound like I'm from Brooklyn now. It's not the same thing. A seller's wrongful repudiation of repair. Seller's wrongful repudiation of repair. And the warranty may expose a buyer, maybe a very beautiful, very perfect buyer. I don't know. Maybe tell me it's a very beautiful buyer. The consequential damages they're not contemplated by the contract or any other code. It's a beautiful code. It's a big beautiful code. It's great. Oh, okay. After this, yes, in the big beautiful code, the remedies. There's a lot that people tell me. There's a lot of remedies, and they may. I'm not sure. People tell me they may be inadequate. In such circumstances, I'm back to Brooklyn. I don't even know what I'm doing anymore. In such circumstances, I'm not even sure. I'm Brooklyn now. In such circumstances, the court might appoint the decline to enforce the exclusion. Welcome to hell, people. 3. Oh, Canadian's tough. Now that's Australian. Good eye. No, that's just Australian. Canuck, hoser, Hey, I was just being really polite, I'll just be really polite when I say the things. I'll just be really super nice, That's Canadian, Okay, we're good there, Okay. In this case, a sophisticated buyer. This poor guy. I like guys. He's a good guy. He's just a good guy, He purchased for $167,000, American dollars. That's a lot more in Canadian dollars. It's no, we cannot do that, That's true. We're Canadian. We're very polite. We can't go there, But we can purchase for $167,000, thing. We got a thing. It was a complex computer thing, It was a computer controlled machine tool, The sales agreement was allocated to the master. We don't say master in Canada, because that sounds like an American slavery problem. We don't even do in Canada. We can't do that here, We can't do that here. We don't do that here, But it was K&T's responsibility, to repair and replace the machine or any defective parts. And you know what? There's a lot of defective parts in the system, We can't talk about that because Justin Trudeau will come and take our money away, But we can't say that. But I'm going to say it because it's the thing, So we're going to do that now, So K&T's responsibility was to repair or replace that machine or any defective parts in order that machine would be, quote, I have a quote now. So I have to do. So it would be free from any. No, that's not right. We have to. We're going to work on this. Hey, this is the second stream, so stand the fuck by. It would be free from any defects in materials or workmanship. Now it's close enough. Now let's go back to the Canadian. Damn it. Or for the shorter of 12 months. No, I'm still an Indian. Damn it. I was doing a Canadian too. My Canadian was on point until, okay, so, hey, I'm Justin Trudeau, Hey, look at me. I'm in blackface, I don't even know what that was. That wasn't Canadian. I don't even know what that was.
Half Indian.
It was it was like an Indian immigrant to Canada. Hey, I'm really polite, I'm okay. I'm back to being polite, No more of that guy. I know he runs a quick. If I say Quickie Mart, I'm gonna go back to India, so I can't say that because I'll immediately transfer back. So, nice day, hoser, Canuck. Hey, keep your stick on the ice, guy. Okay, we're back in. We're back in now, All right now. So for the shorter of 12 months, or 4,000 operating hours. That's a lot of hours, That's more hours than we work in Canada these days, The testimony in the trial demonstrated that the MM180 was a complex piece of equipment. That's what she said, and nor it was a normal operation could adversely affect a wide variety of factors, including deficiencies. Welcome to Canada, Everything is a deficiency. Everything is efficiency in Canada, We have deficiencies in education. We got deficiencies in gender roles. We got deficiencies all over the place. Look at our freaking prime minister, He's a walking deficiency, Canuck, We are not complex piece of equipment and normal operations. I just lost all my accents. Its normal operation can be adversely affected by a wide variety of factors, including deficiencies in maintenance or computer programming for which master's employees are responsible. I don't know if I can do that one. We are not dealing with a piece of equipment. Oh, we have a quote, though, so I went to
Nigerian.
I know, but I don't know if I can do that. What do we do now?
Come into my house, right?
I said, what now? We are not dealing with. I'm just going to be just general African, I think. I don't think it's me Nigerian at all. We are not dealing with a piece of equipment. That sounds Jamaican.
That sounds Indian.
No, it doesn't.
Yeah.
It sounds Jamaican to me.
Okay, Canadian. Back to Canadian then.
But it's a quote. I can't do it in Canadian. Another language. Go.
Let's see. Wait.
Why are you doing a crazy voice like this? We are not dealing with a piece of equipment that either works or does not. It's fully repaired or not at all. On the contrary, the normal operation spans too large of a spectrum. We're on the spectrum for simple characterizations. American Electric Power Company versus Westinghouse Electric Corp. 4018 FedSup 35 through 558 SNDY 1986. That's when I was born. Nor was there, next you can't. Nor was there any contention by Master that KT did not make service calls when requested.
The French.
Oh, she could do the French. You're very right. Oh, c'est beaucoup, moi, merci. But there's no quotes. Oh, there is no. We're just going to finish out here. We have a paragraph to go. I've been on reading this fucking article for 35 minutes. Nor was there any contention by K. I'm just going to cry while I read it. Nor was there any contention by Master that KT should make service calls when requested.
It's not my fault.
It's not KT's fault. Leave KT alone. What was sharply disputed? But wait, now I'm just okay. What was sharply disputed? I'm just gonna do the ASMR thing and be like, what was sharply disputed by Master's claim was that the machine was defective during the first year. Since KT's witness testified that most of the problems encountered during the period were the fault. I'm doing ASMR.
Oh.
I don't know what that is, but since the first year, since KT's wait, I already read that. In our view, the facts in this record do not justify. Wait, you can't see it. Do not justify the fact. The invalid jury's invalidation of consequential damage exclusion and risk allocation agreed to both parties. I hope you're all asleep now. That's all the ASMR I got in me. Master could have offered evidence, although it did not, in the value of the MM180. Oh, yeah, that's what we're talking about. This fucking machine was less than the contract price because of the erratic performance during the first year. We, all of us are fully satisfied that the availability of damages for a breach of the repair and replacement warranty under 2 TAC 171 2 TAC 7142, combined with the return and refund of provisions of the contract of sale not invoked by master, yes, a master, adequately fulfills the UCC's mandate that at very least a minimum. I don't know what accent I'm doing, but I'm going to do it now. At least a very minimum adequate. It's like French and Russian had a kid. At least a minimum adequate remedy are be available. I think it's Serbian, maybe. When a limited remedy fails, it's Mexican now.
Oh, yeah, Mexican.
Yeah, it went from Russian to French to Serbian to Mexican. Okay. When a limited remedy fails, man, if it fails to achieve its purpose, man. For these reasons stated, the judgment is reversed, and the matter is remanded to the law division for a new trial. Well, I fucking hope so, because I have no idea what the fuck just happened. Love you guys. Like and subscribe.